Before we begin, we'd like to give special thanks to all of our sponsors for making this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 6 consecutive years. And thank you to our platinum sponsors, Psychmedics, OraSure Technologies, Quest Diagnostics, and Veriforce. Hello, and thank you so much for joining us for another session of Day with DISA. Today, our background screening session is focusing on California's unique legal landscape, and we're joined by Adam Rosenthal, employment law partner at Shepard Mullin. Adam, how are you doing today?
Very well, Thomas. How are you doing?
I'm doing pretty good.
Excellent.
Before we jump into the presentation, I want to remind everyone that if they have any questions, use the Q&A button at the bottom right of the player. If there's any questions we're unable to answer today, we'll reach back out to you after Day with DISA. Additionally, we're going to make a copy of this presentation available for download on the Materials tab at the end of the session. With that being said, Adam, the floor is yours.
Perfect. Let's get going. All right. Today, we're going to focus on California hiring best practices and pitfalls. Now, for this presentation is focused on California, obviously largest state economy in the country, but also because whether or not you are California-based or not, it's very likely that the presentation will impact you and your employer if you have any employees in California, or if you're intending to have employees in California, or if you want to look out into the future and see what your jurisdiction, what your state may adopt in the future. Often California leads the way in employment law, and this is one area. So let's dive in right now. The focus of the presentation really looks at what is a compliant recruiting and hiring process. And so we want to lay the groundwork right now and walk us through quickly every step of the process, which we will cover during today's presentation. So first and foremost, we'll be focusing on practices within the organization that promote non-discrimination and equal employment opportunity. Now, obviously, every employer in the United States is covered by non-discrimination law at the federal level, and many states, California being certainly one of them, have additional overlay of requirements related to non-discrimination in the workplace, and we'll focus on that. So the centerpiece should be a policies and procedures which promote non-discrimination. Now let's jump to the next step, which focuses on recruiting and sourcing candidates. Now, this goes into the non-discrimination, but we're also going to now focus on some areas where California in particular has highlighted areas of concerns to promote equal opportunity in their workforce, particularly around pay inequality as to gender, race, national origin, and whatnot, as well as issues around ban the box. So laws to promote encouraging employers to hire those who have been incarcerated and come out of the system. Now we're going to go to job employment applications and interviews and cover some topics that focus both or just general best practices for every employer in the United States, and in particularly those in California and those hiring California employees. And then we're going to go back to a discussion around ban the box and issues around hiring those who have been formerly incarcerated, around conditional job offers, as well as testing employees, both psychological and physical testing. And then hopefully at the end of the presentation, we have reached an outcome where there is a successful compliant process and procedure around hiring and recruiting employees. All right, so we said that we're going to set the table first and foremost with the policies and procedures that promote non-discrimination in the workplace. And again, not unique to California, but those employers with employees in California need to be heightened and have their antenna up even more because, as we'll talk about in a moment, there are many more protected characteristics in California than in most other jurisdictions. So the basis of non-discrimination law is that employers must treat all individuals equally by evaluating them by their abilities, knowledge, and experience, and not based on any biases, and certainly not in any discriminatory manner based on a protected characteristic or class. And So why do this? Well, first and foremost, obviously, it's the right thing to do. This is a bedrock of employment law and the really employment relationship in the United States of equality around around hiring employees, but also to the extent that there needs to be additional reasons why, because employers can face considerable liability on a failure to hire claim. Again, that's true throughout the country, but specifically and quite concerning in California, where there are many areas, as we'll talk about in a moment, where an employer can unintentionally or inadvertently violate non-discrimination laws. So let's get going on that. So what are the protected classes in California and under federal law? And here I've compiled a list that's quite long because it's covering both, again, federal and California overlay, and some things which are obvious to anyone who's in the business of advising their companies around recruiting and hiring employees, and certainly in the employment process, whether that's a human resource professional or every frontline manager. We know gender and national origin and color and disability. Those are obvious, but California, we have additional genetic characteristics. Certainly we have, and we'll talk a lot around credit history, unemployment status even. And then lately, and this is real hot off the presses here sitting in early 2024, around pre-employment marijuana testing. So we have a lot to cover in California, and it's a good reminder that anytime you're looking at a new hire or an employment relationship in California, to pay special attention to, are there protected characteristics that we have to be mindful of and ensure that we're not discriminating against, again, even potentially where there would be a good intention, and I'll focus again around marijuana. We still have to be mindful of there may be a protected class of characteristic that we need to focus on and work through. All right. So non-discrimination laws cover every area of the employment relationship. I like to say the employment life cycle from recruiting to termination. Again, focus of this presentation are on the first two, which go to recruiting and hiring, but certainly be mindful and worth repeating that non-discrimination laws cover the life cycle of the employment relationship. So let's talk through what a compliant recruiting process looks like. And again, here we want to focus really on the first stop in the employment life cycle, which is how you're going to advertise that you have a potential job that you're looking to hire for your organization. So, and I want to look at this as almost like layers of, start with Captain Obvious and then really get down to things that perhaps we are doing and I'm certainly seeing out there that we need to be careful of. So obviously we cannot hire, and it's quite important that decisions are not made that would discriminate against a protected class. And affirmative action in the private sector, certainly a very hot debate, not the topic of of this discussion, but to be mindful of in that process. Just again, kind of put a placeholder there. So let's talk about language in an employment, in a job offer or in a recruiting materials. So we want to clearly avoid gender terms. Now, I'm not seeing a lot of that lately. When I started practicing law 20 years ago, it was quite common to see looking for a salesman or a delivery man, those types of gendered language. We're seeing much less of that. But what are we actually seeing, and still raising some concerns, are words that potentially I like to call as code words that could lead to potential discrimination in the recruiting and hiring process. So, for example, something that comes up all too often, looking for a recent college grad. Now, that may be purely a signal to the world that is just looking for an entry-level position. However, if you're an older employee and you are maybe new to this industry, or you're looking to expand and grow in this area, that could be a signal to you that you are maybe not what they are looking for, because you are, quote, not a recent college grad. So we want to be careful about that. Another thing I've seen before, which is of concern, is a job application that for a position that required extensive travel. A sales job required a lot of travel throughout several states on the West, and it said looking for someone who's unattached. Now, again, that would be discriminatory in and of itself, because it's saying we don't want, or we're not interested in those folks who have kids or may be married. So we have to be very careful now. Okay. Also mindful, as just a kind of a heads up, California, and this is, relatively recent case law, has found that employers and their agents can be liable for violating anti-discrimination laws during the recruiting and hiring process. So for those of you who are in the business of recruiting or in the business of providing services to employers to assist them in the recruitment process, you have to be mindful of compliance. And this is on two fronts. One, you have to maintain policies and procedures that are compliant, and ensure that you are complying, again, with all the host of California and federal law and every jurisdiction you're in. But in addition, if you have a client, that is the hiring entity, engages your services to recruit within California, and they tell you, hey, we would like a certain type. Again, it goes back to our code words. It's the incumbent on the recruiting company to say, wait, hold on here. We can't do that because it could potentially result in a discriminatory hiring decisions or processes. So again, a reminder that both the hiring entity and any agents of the hiring entity, third-party providers, can be liable under California law. And then the last issue I want to kind of just jump on quickly, again, it could be its own presentation, but it's worth noting here, is that at the federal level, and in California as well, there's a lot of attention right now on AI tools, so machine learning in the employment arena. And one of the things that we were very concerned about is how machine learning can take, quote, what I like to refer to as bias creep or discriminatory decisions into the hiring process. So, for example, if you engage with an AI tool that sweeps every job applicant over the last 10 years and looks at what are the characteristics of the job applicants who ultimately become successful employees, and in that process, it is favoring, say, younger employees or males or employees from a certain demographic, and weeding out other employees, potential hires, potential employees in the job application process, that could result in a very serious violation of both federal and California law. And again, back to the earlier point, the potential liability or potential exposure is both on the hiring entity and on the agent, the creator of that tool. So it's, those in the AI business, in the employment arena, that are focusing on this, should be engaging in a clear evaluation of the process to ensure that that their tool is not propagating bias in the hiring decision. All right, I want to focus now on California's long history around fair pay and equal pay. Now, it's long been the case that California, again, a leader in this arena, has required that employers compensate men and women equally. And there have been laws that have been on the book for a long time. About 8 years ago, former President Jerry Brown, in his second term as governor, Jerry Brown, I'm not going to promote him just yet, and I think that ship has sailed for Jerry. But Governor Brown really focused on California fair pay and beyond, to really look not just at gender and sex, but race and ethnicity as well. Unpacking that a little. So over the last 8 years, there's a stream of laws regarding what it means to create an equal pay environment. So first and foremost, California, when you look at equal pay between two employees, again, it could be man and woman, it could be employees of different races or ethnicities, and ask, are they performing substantially similar work? It used to be equal work. but that was very restrictive. So the example that we often use is if you're a hotel and you have a janitor, a male janitor, and you have a female housekeeper, and they were performing substantially similar work, but if you see that the male janitor is making significantly more than the female housekeeper, that could potentially raise a concern around equal pay, around fair pay. So I want to be mindful of that. And the new laws also, again, make it more difficult for the employer to establish that there were bona fide factors other than sex or race, ethnicity in a defense. Again, the law is looking, we really focus, a laser focus on the question of whether or not the employer is ensuring that one's gender, one's sex, one's race, one's ethnicity is not contributing to inequality in compensation. Okay. Now I want to focus on the last bullet point here, which has to do with asking about employees or applicants' compensation history in the hiring process. And this, again, is something very important in California, and when you're hiring employees in California, whether or not you're based in California or not. So California pay transparency law, and this is relatively new, about a year old, has some very onerous requirements on employers when they post job opportunities. I want to focus on a few of these. Employers with 15 or more employees in California must include the pay scale for the position in any job posting. And I want to be clear, any job posting means if you're going to post it on LinkedIn, there has to be the pay scale, the reasonable pay scale of what you may pay for that, the compensation for that position. In addition, if you're an employer and you engage a third-party recruiting agency to go out and find you the right employees, you have to make sure that they are posting on whatever social media or job posting third-party resource the salary history, the salary scale, for that position. What does pay scale mean? And this is important here. So pay scale would be what the employer reasonably expects to pay for that position. So what would be improper would be if you're hiring for we'll say for an office manager, a non-exempt hourly position, and you say the pay scale is $16, which is the minimum wage in California, although it's higher in some cities, and $80. Okay, it'd be such a huge range that it really wouldn't be a reasonable pay range of what you expect. So the law looks and says, what are you reasonably expecting to pay? Again, based on experience, knowledge, and skill set, and that's how you make that determination. You don't have to include bonuses, tips, or benefits within that. Okay, and then of course, if you are an employer with 100 or more employees, there's also additional reporting requirements to the state's Civil Rights Department, formerly the Department of Fair Employment and Housing. So that's around information you have to give employees. Again, if you're an employer of 15 or more employees, around pay scale. So what about talking about compensation in the interview process, starting from the job application through the interview process? So the law is quite clear that you may not ask an employee about their salary and compensation history. Now, that's not particularly intuitive for a lot of employers, particularly outside of California, because they say, well, it's an important question to ask because we want to know what are they expecting to receive, and we want to be able to have a conversation to at least match, perhaps, and offer more to recruit them, particularly if it's a job that's difficult to fulfill. And the reason why you can't ask that goes again to the central core component of equal pay law. We know that still to this day, women make approximately 87% of what a man makes for this similar job. And that's, a statistic throughout the country. And so part of the concern here is that if you ask an employee what they made at their last job, and that last job had implicit biases where men were paid more than women, or white employees may be paid more than employees of color. So, right. So any inequality in the compensation system, that it would continue, right? It continue job to job. So by not asking that, the rationale is that we are going to, and somewhat wishful thinking, that we are going to have a more equal playing field when it comes to compensation. Now, that does not mean that if an employee volunteers that information, that the employer needs to put their fingers in the ear and say, I can't listen to you. Certainly, if the employee, the job applicant talks about their compensation history, which is all too common, particularly for sort of harder to resource jobs, then that discussion could be had. Okay. So now let's focus, and I mentioned this earlier, on the ban the box requirements. So the California Fair Chance Act. Now, many states, last count 37 states plus the District of Columbia, have similar ban the box requirements. And that box is, have you been convicted of a crime or have you been convicted of a felony on the job application? And in California, to be clear, you cannot have that on a job application, with very limited exceptions where criminal background check is required by law. We're going to put that aside for right now. So what is the requirement in California? The requirement is pretty clear. If you have a workforce of 5 or more employees, you may not ask about an applicant's criminal history until after the conditional offer of employment has been made. So how it generally looks is employee applies for a job, it goes through the interview, it's a compliant process throughout, and the employer sends an email to the employee, hey, great news, we're making a conditional offer of employment, but we need you now to go through, or we now need to run a criminal background check, as may be standard for the employer or for the industry. Fine. Start that at that point, then the employee gets to decide whether or not they want to continue. Assuming they do, then the background check is run. And as you likely know, because whether or not it's in California or throughout the rest of the country, in order, before you're even going to run that background check, you're going to make sure that the proper that all the ducks are in a row in terms of providing the employee the proper documents and forms regarding the consent to have a background check run. Okay. So let's go through the steps of what it looks like if there's a concern after you make the conditional offer of employment, that an employee has a criminal background and has something in their background related to incarceration or conviction that would raise a red flag for you. So step one, make the conditional offer of employment. As I mentioned before, you tell the employee, we're going to run a criminal background check now. You comply with the Fair Credit Reporting Act, California Investigative Consumer Reporting Agencies Act, all those requirements and regulations, which if you have a credible, solid background check provider, they're hopefully going to do that very well. Step two, report comes back and the hiring manager or human resources looks at it and says, oh, this employee, this applicant, who's now, has received a conditional offer of employment, has a red flag on, and so we need to talk about that. We need to look into that. Okay, there's some criminal history. So it used to be in California under the Fair Chance Act, under the Ban the Box law, that the employer was just to look at 3 factors: nature and gravity of the offense or conduct. So how serious was it? And the more serious of the conduct, right, of the act, the criminal behavior or the conviction, then perhaps the more likely the employer would say, we're going to take a pass. And that's the time that has passed since the offense or conduct occurred. So is it recent? Is this individual just coming out of incarceration, or was this a 30-year-old conviction? Right? That could weigh into the decision. And then obviously the nature of the job held. Does it even matter based on the nature of the conviction? Okay. So those were the 3 requirements until this past October of 2023, California, as it often does, and looked at this and said, you know, we are still seeing a problem here. And the problem being that the unemployment rate, even at a time where unemployment is historically low, the unemployment rate for those who have been incarcerated, been through the system, the criminal justice system, is still unnecessarily low, and that those individuals are not being given a fair chance, right? That's the name of the law. So as of October of 2023, regulations now require that the employer engage in a more thorough analysis, and really looking at a number of factors to determine whether or not the nature of the offense, the gravity of the offense, and the timing of the offense should impact the employer's decision to not offer, or the offer's already been made, so not continue with the offer that is go from conditional to a unconditional, non-conditional offer. Some of these things I want to focus on. Whether the harm was to property or people. The law says, California says, you need to analyze that and make the determination if it was a property crime that would potentially, again, depending on the job being applied for and the nature of the industry, that would be less severe, less significant than a crime of harm to a person. Another thing which is quite interesting is there's an analysis that they expect the employer to do, which is not easy. And we'll talk about how the employer is supposed to navigate this, because to be very, very candid here, some of these factors are quite challenging in the real world, as opposed to often the world that the regulators live in. And one is to look to see whether or not a disability, potentially including drug addiction or mental impairment, contribute to the offense. And whether or not a reasonable accommodation could mitigate that. Again, that is a challenging level of analysis for an employer. It can be challenging for a social worker or someone involved in the criminal justice system. But again, these are the guidelines that we must be mindful of. And obviously, the age of the applicant, youthful indiscretions versus and then years of a clean record should be something the employer should consider in favor of making that job offer permanent, unconditional. Okay. In addition, we're supposed to look for and be particularly mindful of the duties of the job, whether or not the context in which the conviction occurred will likely arise in the workplace. So the example I like to give is if you have made a conditional offer of employment to an individual who's going to be a delivery driver for you, and that individual has had multiple DUIs over the last decade, including spent time incarceration, that would be potentially a very serious red flag, and that may be reason enough to, as we'll talk about later, to revoke that job offer. However, if the position, it's a remote job, the employee is going to be working from home, and other factors suggest that the employee is in recovery, then it would be less concerning. Again, there's this individual assessment, and almost similar to those who are familiar with the interactive process in the context of disability accommodation. This would be kind of a cousin of that, related to the California Fair Chance Act. Further, and you'll have this presentation, so further factors, additional factors that hiring companies, organizations have to consider when there is a criminal background record has been performed and there's a red flag. Again, age, we talked about, and disability, the likeliness of reoccurring. All these factors, again, should be the hiring manager or human resources professionals in conversation with the hiring manager need to assess before making a determination that there is going to be a potentially revoking the conditional offer. So let's go back to our steps. So step 3 now is assuming, okay, so step 2 is you evaluated the job application. You evaluated the criminal background check. And if you've determined, you, the employer, have determined, hey, you know what, this is a very serious red flag, and we think it's serious enough to, notwithstanding all the requirements that the analysis that we did, that it's serious enough that we are going to consider withdrawing the offer. So step 3 then says you have to send a pre-adverse action letter to the applicant specifying why you're withdrawing the conditional offer, and the factors that you've considered. Now, you don't have to, I don't think you don't have to give a novel here. You don't have to give certainly you don't have to provide privileged communication if you consulted with in-house or outside counsel, but you want to give the applicant an understanding as to why, based on what the criminal background check has shown, you have serious reservations and are not going to move forward. The applicant then must have at least 5 business days, not 5 days, 5 business days after receiving the letter, and to provide additional information, mitigating circumstances. Perhaps there was an error, Social Security was run, flipped, or some reason why, some information that the applicant should give or has an opportunity to give to the employer to say, hey, I want you to rethink your decision. That process goes forward. Again, this is similar to the interactive process in the disability context. And then step 5, if the employer has, after reviewing the information the employee gave in step 4, or the employee, the applicant here does not respond, then step 5 says that the employer at that point, if they still are confirmed that they do not want to go forward with this applicant, they have to send now the adverse action letter. This is the second letter, again, informing the candidate of the decision. All right. Enough about ban the box. Let's move on to topics to avoid when interviewing a job applicant. I took these from a book that I wrote several years ago. It was my COVID project. These are kind of the 8 topics that I strongly advise my trained managers and other employment attorneys. These are the things that I see coming up too often, both in context of litigation and just in conversation with HR professionals, and things that we need to train managers to avoid during the applicant process. Number 1, family matters. So inquiring about how many kids they have, or what their family planning plans are. Right? So our questions of, hey, are you planning on having any kids in the next 2 years, or how are you going to manage the job when you have 6 kids at home? Those types of questions, inquiries are quite problematic for all the reasons we talked about before, creating an equal opportunity workforce. Anything to do with the applicant's age, commenting on the applicant's age, quite problematic. Presuming that an applicant's religion would prevent them from doing their job. The famous Supreme Court case, U.S. Supreme Court case, involving a big retailer, Abercrombie, where they presumed that an employee, a Muslim employee, a female Muslim employee who wears a traditional hijab, would not be able to satisfy the dress code or the style requirements of the employer, and proceeded not to hire her. That obviously was as the U.S. Supreme Court found, was a violation of anti-discrimination laws on the federal level, and would be in California as well. And then I'll hit up number 8 here. Is obviously be very mindful when we talk about disabilities, mental and physical disabilities. Invariably, that may come up in the job application process. We'll talk about in a moment in post-offer, pre-hire testing, but things we need to be careful of and train our managers around. Okay, let's jump now to aptitude tests. This is still somewhat of all the rage in certain sectors. And I want to be careful here. So, and this is very much true under both federal and California law. We'll get into California specific in a moment. But if you're going to have your prospective employees, your job applicants, perform some type of aptitude test, it's important that you make sure that it is a valid test. So I had a question a few years ago at a presentation where the HR director said, my CEO really loves the Rubik's Cube. And he thinks that whether or not, if you can solve a Rubik's Cube within a minute, then you are the type of employee that he wants to hire. So my first comment was, I asked everyone to say, all right, well, how many of you would be hired by this company? And 3 people put up their hand. But I asked why, and the head of HR said, well, he thinks that it goes to show, how you could solve problems and how analytical you could be. Okay, is that a valid test? I mean, that's not my area of expertise, but I don't think it passes the smell test, because whether or not you can solve a Rubik's Cube in under a few minutes isn't really going to hit up the 3 areas that are required to be validated as a aptitude test. Does it specify the trait or characteristic the test is supposed to identify? Yeah, maybe or not, likely not. Is it an important component of the job? Does what is being tested, is that crucial to the job that is being hired for? And then third is, will it accurately predict or correlate with what is being is the component of the job? So when you think about the types of tests that you're going to give employee applicants, you want to make sure that it really is consistent with federal law here around being a valid test. And if there's concerns that it is not a valid test, it doesn't mean that you throw it out. It means you look at the test and say, how do we refine it? How do we make it better? And then ask yourself, again, importantly, is it worth giving this test to job applicants, and what are we really looking for? Does it matter? Do we care about the results, or are we looking for how they approach the test? Again, that may be sufficient reason to keep it, but the employer has to think through that. When giving aptitude tests, it's also important to be mindful of potential discrimination in the test itself, right? So if the test, if reasonable accommodations can't be made for disabled employees to take the test, that would be a concern. Another thing which has come up quite often in this area of the law are computer-based tests and potential discriminatory concerns related to age. So if you have an older job applicant who may not be as savvy around just a certain computer interacting with a computer interface with an operating system, and that is a initial hurdle that the applicant would have to get over, then there could be a concern of discrimination. Again, it's not necessarily going to trigger a bunch of red flags, but issues that the employer should be mindful when having aptitude tests. All right, now I said we'd focus on California. So I want to be clear here around medical and psychological testing. With few exceptions, it is unlawful for an employer in California to conduct a medical or psychological examination or inquiry of an applicant before extending an offer, so before that conditional offer of employment. Okay, that's pretty clear here. What about post-offer? So what we call fitness for job tests, that is allowed under certain circumstances, and I want to focus on how it can be compliant and what an employer will need to satisfy to show that their post-offer test, whether it's a psychological or medical, quote, physical fitness for job duty test, is compliant. Number one, the conditional offer has to have been made. Okay, similar to the ban the box, you don't engage in this level of intervention with the employee. So you're not going deep with the potential applicant until you've made the decision that you made a conditional offer of employment. So in order to be compliant, number one, the test must be given to all applicants, all conditionally hired employees in that similar position. So the example would be if there was a physical test, let's say we have to determine whether or not you can carry 50 pounds over 20 feet repeatedly, because that's the nature of the job. If you only gave that test, only administered that test to female applicants, that would be a serious red flag. Same thing, let's say, again, with age. If there was a special driving test that you only administered to applicants over the age of 50 and did not administer that test to applicants over the age of 20, between 20 and 50, that would potentially create, and that would create a concern under California law. Second, if the result of the test mean that the applicant is going to be disqualified, and so the conditional offer of employment has been revoked, or will be revoked, you must give the applicant an opportunity to submit independent medical opinions or considerations before making that determination. And then the third point here is that the information related to those tests should be kept separately. Those are highly confidential, particularly medical records. And so you want to be mindful of the regulations around keeping sensitive confidential information separate from your normal personnel file. And then if you're going to withdraw an offer, and this kind of, we're going to now go full circle after doing performing or administering a medical or psychological test, then you still has to have the inquiry around the interactive process related to accommodating a disabled employee, both physical and mental, or you obviously have to make a determination that you're withdrawing the offer because the applicant would potentially endanger the health or safety of themselves or others. All right. So the final topic, again, somewhat hot off the presses, has to do with post-offer drug testing. So in California, you can still post-offer, pre-hire, administer drug testing to employees. But as of this year, if you're going to do it regarding, and you're going to be testing for cannabis, you've got to be very careful that you don't end up violating California law. Because as everyone knows, California, like many states now, allows for the sale of cannabis products, of marijuana, and is very liberal marijuana rules for adults. And that now means there's certain protections in the workplace. And so specifically, you cannot test a job applicant or an employee for using a marijuana drug test that reveals non-psychoactive cannabis metabolites, which is a long way of saying, that you can test for, and we'll talk about how you can do that, active THC. So simply put, you can test to see if the employee is high as a kite when they are in front of you, but you can't administer a test that would show that the employee smoked marijuana over the weekend, or or had some cannabis use over the weekend, and they are no longer under the influence. That type of test that would trigger non-psychoactive cannabis is unlawful in California. And so how should you test to see, and you can still test to see if the employee has active THC? The easiest way would be to do an impairment test. And so you're going to look at what would be a baseline activities versus potentially, and then show, well, if the suspicion that the employee or job applicant, usually it's the employee, is under the influence currently, and that would potentially trigger a determination that the employee has violated your policies, if you have them, around drug-free in the workplace, or a test that only looks to active THC within the last few hours. Those tests are few and far between, because it's very difficult to determine that currently. So that is what I have for you. This is I'll pop up my my LinkedIn QR code if you want to connect on LinkedIn. It's been great chatting with you. And Thomas, I understand there's some questions.
Yeah. Hey, Adam, thank you so much. This was great information, and I like the QR code. So we'll leave that for just one more second. And all right, Adam, I know we're really, really tight on time, so I think we're just gonna have to end up calling this.
All right.
I know when you and I talked initially, you said this is going to be a lot of information for 30 minutes, and you weren't kidding. It's extremely impactful. This recording will be available to everyone after the conference. And additionally, if you asked a question today, we obviously weren't able to get to it, but we will get those questions over to Adam, work with him to get those answers, and get them back out to everyone that attended today. So again, thank you so much to everyone. Thank you, Adam, for being here today.
Pleasure. Thank you, Thomas.
Yeah. And again, thank you for being a part of Day with DISA, to everyone that's attended our sessions. And we hope to see you tomorrow and possibly in Houston at the House of Blues on Thursday. Thank you so much. Bye-bye.